I'm sure you've had a chance just to skim through part of what has come out of Parliament today in terms of the report and the amendment that they've put on the table. Your initial impressions of it?
Look, I think it doesn't come as a surprise in that you must remember that the mandate that was given to this Joint Constitutional Review Committee was a very specific one, and which said, which sought out to ask from the public whether or not it was necessary to amend Section 25 of the Constitution. The interesting issue there is that an issue of whether or not we need an amendment is not just a matter that must just be determined by populist interests. It is a very technical legal matter, and one which a lot of experts or commentators have said that we already have enough within the Section 25 of the Constitution to give effect to land reform. So it's quite an interesting development, but it's also an interplay between law and the emotive nature of the land question in general.
Let's talk about that, because it's obviously part of the argument that's being made by the DA, the Freedom Front Plus, and they together with COPE are opposing this amendment, and it's something that we heard from Agri-SA in the last hour, that they believe that this is being pushed through for populist political reasons. And at the same time, we heard from people that the members of Parliament went to speak to, who overwhelmingly, at least from the sense that we got, seem to be in favor of land expropriation without compensation. So at which point do we balance those views then and almost have insight into how this committee came to the decision that they did today?
Look, it's a very important question, and that one that must be determined. As I said, it's an issue of law, law as it is, and also what the public sentiment is. I don't think that the two necessarily need to be mutually exclusive. I think the question that needed to be asked was, what is wrong with land reform, without necessarily pinning the question squarely within the Constitution? Because the issues that have dogged land reform have been a multitude of issues, including issues, such as budgeting requirements from the Treasury. It's been lack of post-settlement support. It's been the failure to legislate on, for example, redistribution. So whilst I also don't want to be cynical around explaining away, or rather making explicit under what circumstances expropriation could happen, I think it's important to realize that land reform is not just about expropriation. Expropriation is one mechanism that can deliver. So even if we do amend, and I think there is a basis on which the other side of the argument has said we do need some level of explicitity, we need to realize that even with the amendment itself, that on its own is not going to deliver what we believe has dogged land reform. So we need to separate the land issue as an emotive issue, as an objective that must happen, as an issue of social justice, as against what structurally have been the issues with it.
Let's talk then about the language used. One of the issues also raised around the current language used in this proposed amendment is that, in fact, it's too broad. Some people felt that what they would have wanted to get out of it is perhaps a bit more specifics, that at least set the parameters within which expropriation without compensation would take place. And, we still have a long process to go through before the bill is passed. So should we be overly concerned now in terms of the language, the fact that it is as broad as some have indicated?
I think that question actually puts into the spotlight the point that I'm driving home, and that is we can legislate as it is, for example, a redistribution bill that's going to tell the public and every stakeholder to say under what circumstances can you expropriate without compensation? What kind of land is going to be regarded as land that would be adequate for that? Who would be the beneficiaries of land expropriation without compensation? We're able to do that. For example, we've set with the expropriation bill that's sat on ice for a long time. We could bring that amount of detail within the expropriation bill when it becomes enacted, or even by introducing a redistribution bill. And in fact, another argument can say the Constitution is an aspirational document. It is not exactly the correct place to put the level of detail that should actually be done in subsequent specific legislation.
Do you think that there also needs to be a disclaimer of sorts that comes with whatever recommendations are added to this as it goes through the various legislative frameworks? And this is specifically to the fact that as we have the issue of land now, there's still a question of those outstanding land claims which have not yet been attended to. You know, we hear ongoing stories of people that have waited even 20 years for their matters to be settled. And do you think that this is an opportunity for cases like that to perhaps even be expedited, because those would, to me at least, seem to be the most urgent, because these are people that have been in the list but have seemingly not have not had their issues addressed?
Yeah. Look, with land reform, I don't think you can solve one problem and ignore others. There are a lot of different things and a lot of different interventions and mechanisms that we need to put into place. And one of those is, yes, what do we do with our standing land claims that have been long outstanding before 1998. And added to that, we know that the statistic is that the Commission has received more than 3 times the number of outstanding claims post the amendment. So there's got to be a very systematic framework that deals with all the different challenges, and instead of honing in on this issue of the constitutional amendment as if it's going to be the silver bullet.
All right. Let's leave it there for tonight. Thank you so much for your time.